And now it's time for another case law update. Today, we're discussing Wiggins versus Southern Securities Group, LLC, a decision from the Supreme Court of Mississippi that takes a closer look at the enforceability of a non-compete provision tied to a business buyout and continued employment. Here's what happened. Robert Wiggins founded Southern Securities Group, or SSG, a wealth management firm, in 2008. In 2017, Brandy Hoover joined the firm, and in 2018, the parties entered into a transaction where Hoover would purchase Wiggins's ownership interests over time. On April 1st, 2018, the parties executed an LLC Operating Agreement and purchase and sale agreement at the same time. The operating agreement included a non-compete provision prohibiting a member from competing with SSG within a certain geographic area while affiliated with the company and for 2 years thereafter. The PSA governed the buyout and provided that once the buyout was complete, Wiggins would remain employed by SSG and could only be terminated for cause. By June 2022, Hoover completed the buyout and became the sole owner of SSG. Wiggins stayed on as an employee. In January 2024, Wiggins was terminated for cause. The next day, he began working for a competing wealth management firm in the same area. SSG and Hoover filed suit, alleging, among other things, that Wiggins was violating the non-compete provision and sought injunctive relief. The trial court granted a temporary restraining order and later entered a preliminary injunction enforcing the non-compete. Wiggins appealed. The key issue before the Mississippi Supreme Court was whether Wiggins was still bound by the non-compete provision, even though he was no longer an owner of the company or a member when the alleged competition occurred. Wiggins argued that once the buyout was complete in 2022, he stopped being a member of SSG and therefore was no longer bound by the company operating agreement nor the non-compete it contained. In his view, the non-compete could not apply to him as a mere employee. The Mississippi Supreme Court disagreed. The court focused on the integrated nature of the transaction. Although the non-compete appeared only in the operating agreement and not in the PSA, the two documents were executed simultaneously, referenced one another, and were part of the same overall business deal. The court emphasized that Hoover's purchase included the goodwill of the business, and it would have been unreasonable and illogical for Hoover to pay $500,000 for the company without protection against immediate competition from its founder. The court also rejected Wiggins's attempt to reframe the timing of this restriction. The non-compete prevented competition during affiliation and for 2 years after affiliation ended. The court held that Wiggins's affiliation with SSG did not end when he stopped being an owner in 2022, but rather when his employment ended in January 2024. As a result, the 2-year non-compete period began running from his termination date, not from the completion of the buyout. So why does this matter? Non-competes and their enforceability are tricky. I can't tell you how often I hear, "Yeah, I have a non-compete, but it's not enforceable." Well, as this case shows, that's not always true. That's it for this case law update. I'd like to thank Jacob Wilson, an associate in our Denver office, for his help on this update.